All right, court has considered case law, the arguments counsel have read the motions. Under the circumstances, find that Judge Evans was properly appointed as a senior judge, that she did make her election no later than the 90th day after her retirement. She actually did so preemptively, and there is nothing in the law that would preclude that. Further, Chief Justice Heck's letter to her says it would be effective on her retirement day. Therefore, the motion to vacate is denied. We will now move towards the motion to recuse. I will also note for the record that the defendant, Mr. Robertson, is present via Zoom.
Thank you, Your Honor.
All right, you may now proceed with the motion to recuse.
Your Honor, as you know, moving to recuse a judge is a fraught and difficult issue. There has been a suggestion by the state that we somehow waited opportunistically to do this 3 weeks before an execution, and that is a false representation in the history. And it is also a false representation to suggest that only after 7 years of her litigating the case, we are now complaining. I will say on the record, I believe Judge Evans is a very smart woman. That is one reason. It was stunning to me when her findings issued in the habeas proceeding that is underlying this current matter. We had spent days in this very courtroom and several years of litigation to bring evidence, including 6 highly qualified experts. We overwhelmingly satisfied our burden under Texas's trailblazing junk science law called Article 11073, as well as under state and federal law. A new record was created, 13 volumes, thousands of pages. We submitted proposed findings, which are among the exhibits to our motion. The state submitted proposed findings. You compare those 2 documents, on its face, it suggests something is terribly wrong. The state's proposal, we contend, and we have raised this in previous filings, has gross omissions. It simply does not identify most of the evidence. And yet, as officers of the court, they had an obligation to honestly provide a summary of what had gone on in this case. Instead, it is grossly misleading. The few references made to any of our witnesses are inaccurate. They attribute out-of-context statements, and this is like 2 or 3 statements to a few experts, something they said on cross that doesn't even match how they characterize it in the findings. So I have never seen anything like this. I do principally death penalty work. Death penalty work involves the most serious consequence, as is self-evident. So for a representative of the state to misrepresent what had gone on in years of litigation was shocking. But I thought the contrast was obvious, as was the record. But regrettably, Judge Evans essentially adopted verbatim the state's grossly misrepresentation of what happened, making very few little changes. One of them was conceding that the doctor who performed the autopsy had in fact testified about shaking, which the state was trying to bury. They were trying to turn the entire shaken baby case into a case about battery, when we had just demonstrated overwhelmingly there is no evidence of a battery. This is a classic shaken baby case, as its experts said at trial, as prosecutors said. The battery language at trial was completely irresponsible, untethered to evidence, and based on the admissions of that pathologist, cannot withstand any scrutiny. But they were taking this position, wasn't a shaken baby case, but even if it was, shaken baby science is fine, and deny relief. Judge Robbins, of course, as a district court judge, had no power to say no new trial, but she had extraordinary power to frame for the higher court what the truth was. And she did not, in this moment, do her job. And it was inexplicable. And I will say, I have great respect for how she conducted herself. It was one of the heartbreaks of my own professional life, not to lose, but to have a jurist behave in this manner when a man's life is at stake, and a man's life who is innocent of the crime for which he was convicted. So she denies all the evidence. It's not mentioned. Denies that we should get relief, and that goes up to the CCA.
And the Court of Criminal Appeals on October the 10th denied they denied your all's petition, did they not?
What the Court of Appeals did is refuse to consider it. And they didn't even issue a written decision.
Well, there was a concurrent opinion.
There was a concurring opinion, which we have now responded to, Your Honor, with a subsequent writ application.
And I see that, but again, under the rules of procedure, Rule 18A and B, the rulings of the court in and of themselves are not sufficient grounds for recusal.
Correct, Your Honor. That is a fundamental component of recusal law. But I'm just trying to talk about the timeline. I have no reason, though it is hard. We are in a rural county where, of course, people know each other in the community. You have only a handful of judges. You have the DA, everybody in this tiny little community. We had anxiety from the outset because the trial prosecutor, one of the two members of the trial prosecutorial team, is one of the sitting judges here in Anderson County. This was a very painful situation. But we did not have evidence, and a hint that there was a problem with Judge Evans' ability, potentially, to act in an impartial manner until she retires. And she retired, well, until she issued these findings that were completely out of whack with the record, and then announces her retirement and is gone. Then we have no case pending. But somehow, behind the scenes, and we don't know the facts here, but we know it was behind the scenes, and we know it's uncontested, and we're not given notice. Somehow she gets assigned. And that in itself adds another factor to the recusal puzzle. Why is a retired judge wanting to reach in and participate in a death penalty case that has been highly contentious? And why was there no notice to the defense when we would have had a chance, potentially, to object? That's the legal issue right now before the CCA as of last week.
But again, even if you thought you had grounds to object, you did not object in the time frame prescribed to an objection for a judge once you received notice.
And Your Honor, I will say that is absolutely true because we had no inkling under current law that we had a right to an objection. This decision, and I shouldn't say decision, this mandamus proceeding is the first time it's been litigated because